Well, good evening, everyone. Thanks so much for coming. Dr. Hughes, thank you very much for that wonderful introduction. Vandita, thank you for all your arrangements and for approaching me to be here. So, great pleasure to be here, my first time speaking at Cambridge, and what a lovely evening it is. So I'm delighted that you've chosen me over the sunshine. But maybe we can make some sunshine in this room later on through our understanding of what is the impact of race and discrimination on human trafficking and what's needed to start unravelling the tension points. So I just wanted to start with telling you about a case that I wasn't involved in, but it's a case that I think is a good one to talk about. So remember Hurricane Katrina in America, how it ripped apart a lot of the infrastructure in the United States? Well, after that happened, the US government put out a tender for contractors to come and lobby and compete for the government's contract to rebuild those areas of vast destruction and infrastructure. And the contract was awarded to Signal, which was a US-based construction company. What Signal did is, knowing that it wanted to make massive profits and pay very little, it recruited skilled labourers, labour construction workers from India, and brought them to America to work on those areas of construction. It promised the workers green cards and said that they'd be able to bring their families with them later. They were recruited through a recruitment agent, which means that often, and in this case for sure, each person had to pay a certain amount of money to get the job, which meant that they were putting themselves into debt before they started their journey over to America. Some of them sold land, others took loans out, all believing that they were going to be paid well, treated well, and there was a prospect of a bright future for themselves and their families. When they got to America, they were put to work. They were made to stay in a kind of concentration camp style setting, which was only for those Indian workers of Signal and not for national Americans, workers of Signal. They were made to work all hours for very little pay. They were kept in deplorable conditions. Soon after the men arrived, they were threatened that if any of them left, they would have sanctions imposed on them. And they weren't getting the money that they were being promised. It then transpired that there was no green card. It was a lie. But they were transported into America lawfully under a visa system for labourers. But there was no chance of any long-term possibilities for them or prospects in the country. And as time went on, and the workers realised that they were getting less and less pay, they realised the huge significance of their predicament and that these debts that they'd taken out in their home country were not going to be able to be paid off, which meant that they'd made the wrong choice. Now, Signal continued to perpetuate trafficking and exploitation of those men. As time went on, one or two men even tried to commit suicide because the burden was so heavy in terms of the realization of there being no hope at financial recompense. And a brilliant organization in the southern states of America called the Southern Poverty Law Center, which had actually taken lots of the Ku Klux Klan cases and set precedents in America, took on these cases. And it was a fantastic operation because they then got lots of the white-collar, very posh, very well-established law firms to give pro bono hours to work with them on these cases. And they brought the Signal litigation, which was extremely important case that shed light on race as a form of discrimination in terms of the human trafficking of those men to the United States. The case was taken forward with just 5 or 6 of the men originally, like as a test kind of case, because Signal was completely contesting every allegation. And it went to trial, and the court found in favour of the trafficking of the men and their racial discrimination. And it led to an award of around $5 million US. And then more of the group then were involved in the next tranche. Ultimately, it led to a settlement of around $20 million US. And Signal then went bankrupt because its name was over, its reputation was over, and it had to be held accountable for what it had done. No shareholders wanted any part of it. So it's a good story to start with because it's a very overt case of race discrimination and human trafficking. Now, many of you will already know the definition of human trafficking, and some of you might not. So I'll remind you that it's quite a strict legal definition. It requires one of 3 different core elements. One is that there's an act, and that act is definite. It's one of 5 things: recruitment, receipt, harbouring, transportation, or transfer of a person by means of, which is what I call the trafficking trap: abuse of a position of vulnerability, threats, force, coercion, abduction, abuse of power. And the end result is the 3rd core element, which is the intention to exploit. Now, that intention to exploit is not defined in any strict manner, insofar as it's always an open-ended purpose of exploitation. All of the treaties, whether it's the UN Palermo Protocol from 2000, which gives the first internationally agreed definition of human trafficking, which is the one I'm describing now, or the Council of Europe Convention on Action Against Trafficking in Human Beings, 2005, and the EU Directive of 2011 on trafficking. They all, in many ways, explain that where one of those means is used, the abuse of a position of vulnerability, the threat, the force, abduction, etc., then a person doesn't give their consent freely to what happens to them in terms of the exploitation. And so it says that consent must be rendered irrelevant where any of the means are used. Now, coming back to exploitation, it's an open list. It says slavery, servitude, forced labour, removal of organs, sexual exploitation. And so those are the agreed, bottom line forms of exploitation. But things, are developed much more than that. And certainly in a number of the cases that I was involved in, trying to bring cases to uncover victim status in cases that otherwise would have been thought to be criminal offences cases, where trafficked victims were being prosecuted, for example, for immigration offences or for cannabis cultivation, then it was quite difficult to shoehorn those cases into one of those forms of exploitation. And actually, the VCL AN case, so my case was AN against the UK, that case failed back in 2012 in the UK courts because they refused to accept exploitation for the purpose of criminal activity as being, recognised as something to protect victims who were being required to do, for example, the cultivation of cannabis. But things moved on, even in international law, and by 2011, moving on from the Palermo Protocol on Trafficking of 2000 and the Council of Europe's Trafficking Convention of 2005, the EU directive actually expanded that list of exploitative aims to include the exploitation of criminal activities, which meant that when I then argued the case of L and others, which was another case involving non-punishment in 2013 in the domestic court, I was able to win by showing the court that the use of a person for criminal activities is something that the law is actually able to support protection of. But coming back to race, how does this, play out? Well, staying with the Vietnamese cases, well, actually, let's take a step back. So the first case I brought on non-punishment was a case called R&O in 2008. This involved a young Nigerian girl who'd been trafficked into the UK for sexual exploitation. She was held in a brothel. She was abused there. She was an innocent girl. The reason why someone was able to capture her in Nigeria is because of a vulnerability that had arisen culturally, which was that she was promised by her family to be married to a man who was in his 60s, and she was 16. So she didn't want that marriage. And so someone in the village heard that she didn't want that marriage and said, look, why don't you come with me? I'll take you to England and you can get a job as a nanny or go to college. And so that's how she ended up agreeing to come to England. When it's a case of a child, by the way, those three core elements that act by means of for the purpose of exploitation, you never need any of the means to show in a case of a child. You don't need to show the child was coerced or threatened or deceived or that a position of vulnerability was abused. Why? Because children are vulnerable by virtue of age alone. We can get a child to do pretty much anything unless, like Claire and myself, you have a teenager. That's a little bit of a different problem. So in O's case, I was approached by an NGO, this is back in 2008, called Hibiscus, and they were just helping women in Her Majesty's Prison Holloway, any women who had been convicted of anything, just asking what their needs were. And they came across a girl who they thought was trafficked. And they came to me and said, Parosha, we think we've found a girl who's a victim of trafficking, serving a sentence in an adult prison. So I asked the Poppy Project, which was at that time the main and the only victim support organisation in the UK for trafficking, to please go to the prison and meet this person and take a statement from her and in their own expertise to identify whether she was trafficked or not. And they came back to me and they said, yeah, she's a victim of trafficking. So when I heard about her case, it struck me that I had to act to bring a case to uncover what had happened to her and to overturn her criminal conviction. Now, her criminal conviction had arisen because she had been saved by the other women in that brothel in terms of they helped her escape, they gave her an identity card, a fake one, said, go down to Dover docks and get on a coach to France, because she said she had an uncle that she'd heard about when she was younger who lived in France, so she thought she would be safe there. They thought she would be safe there. They gave her money, they gave her the fake ID, they said, get out of the country, because as soon as you're gone, the trafficker's going to come after you. She was down at Dover docks on board a coach bound for France when Border Force came, found that she had a fake identity card on her, and they arrested her and they took her straight into detention. Now, they asked her how old she was, and she said 34, because that corresponded with the age on the card, which incidentally was of a white woman, and she had her finger over the photo when she was showing it, but she didn't know what else to say. She was kept in cells overnight, and the next morning they asked her again, how old are you? 21? She didn't know what to say. There was no one to advise her. Eventually, her barrister and solicitor met her. They told her that she should plead guilty to the offence of using a fake ID card. They would use in mitigation her history, and that's how she ended up before a female judge in a Crown Court for adults at the age of 16 as a victim of trafficking, pleading guilty and getting 8 months imprisonment rather than 12 because she had told the truth. So this was the first case on non-punishment, which is the right to protection for victims of trafficking who are compelled or who commit unlawful acts as a direct consequence of their trafficking. And I took that case to the Court of Appeal. I asked a good colleague of mine, Peter Carter QC, to help me because my voice wasn't known in the Court of Appeal. I thought, even though I've got the, expertise in this field, and I've got the legal acumen. I didn't think the Court of Appeal would listen to me, and I knew that there was a lot riding on it. Peter was an excellent, leader in human rights world at the bar and in the criminal bar in particular. So we did the case together. Why is this relevant about race? Well, when we looked at the police custody record that night that she had stayed there, one of the policemen had written "small black girl." But no one took any notice of that. And even her own lawyers didn't take any notice of that. They didn't question her. They had no care to ask her, "How old are you?" And in understanding her case, that she was running away from being abused sexually, frankly, from a man so much older than her, there was no courage to say, "This is wrong. We're not going to advise you to plead guilty. We're going to try and, get the case stopped and do what we can." And so sometimes what you find in these cases, wherever they happen to be, is a lack of courage at the very first moment of detection, where courage is needed, because it's not black and white. There's no law that's just going to shine out and say, that person should be protected. You have to piece it together. And so this is something that is always necessary in cases that are novel or in cases where we see something going wrong. And it's really through partnership that the right outcomes can be achieved in these cases. So it was an interesting case legally, and I know a number of you are from this law faculty, because we had at that time, in 2007, signed the Council of Europe Convention on Action Against Trafficking in Human Beings, which I call the Trafficking Convention. And that included a non-punishment provision under Article 26, but we hadn't ratified it. Also, I noticed in the preamble, it talked about there being an absolute paramount objective to protect children and to prevent discrimination. And so in terms, how can you articulate a right to non-punishment before a court when it's not in the law? We used something that I had studied 100 years ago during my undergrad, which is called the Vienna Convention on the Law of Treaties, 1969. And there, I think it was Article 18, said that where a state has signed a treaty, then it shall be deemed to be obliged to act in accordance with the spirit and purpose of that treaty. And the Court of Appeal accepted that argument. So we won a case on the back of a treaty that was not in English law, but had as a priority the protection of children. And in exposing each part of that jigsaw, the Court of Appeal held that this was such a shameful set of circumstances, it must never happen again, and found a breach of Article 6. So that's the beginning of the story on non-punishment, which later became, years later, what you know already in AN against the UK, linked to VCL. So VCL and AN, VCL is named first because they lodged their case in Strasbourg a day before we lodged it. Our cases were separately argued, but they were joined together for the judgment. It was only in AN that Greta, which is the monitoring body of the Council of Europe, intervened, and also Anti-Slavery International. But the outcome was, of course, excellent for both cases. And in fact, the pleadings on damages in AN's case, which I drafted, were the ones that the court agreed with to award the 25,000 euros in compensation to AN. In VCL, they pled damages but never particularised them. So there were differences in how the cases were run, and ultimately the outcomes were excellent, very unanimous findings against the United Kingdom of breaches of Article 4 and 6. And you may or may not know that the United Kingdom tried to flip the case up to the Grand Chamber of the ECHR, but they were refused because there was no error of law at all arguable. So that was the first case involving trafficking where I could see a tension when it comes to arguing cases relating to race. And yet there wasn't so much tension because the Court of Appeal accepted it straight away. And then when I came to argue N's case in 2011, which became AN in Strasbourg, I genuinely did not think it could ever lose. By that time, there was absolute wealth of evidence documented not only by NGOs, but accepted in police guidance, that Vietnamese boys between the ages of 14 and 17 were being trafficked into the United Kingdom for the purposes of cannabis cultivation. So when a government has that information, they should be acting to prevent. But there was no interest in preventing because it's just something else that's, mentioned. The police's own ACPO, Association of Police Chief Officers, so constables, so, officers, sorry, so higher than constables. So even their own guidance said that when the police enter a cannabis factory and that there is a Vietnamese child there, they are duty-bound to operate a child safeguarding approach and to remove the child. But it wasn't happening, and ultimately, why wasn't it happening? Of course it was about race. Of course it was about racism. Of course it was about discrimination. You walking into a factory, which in N's case was a disused commercial warehouse, the windows were bricked in, the door was bolted from the outside, there was between 500,000 and £1 million worth of cannabis in there, and you find children there, no adults, just children, sleeping on sheets, on concrete floors. Doesn't that tell you that this is modern day slavery? But if you decide to just go and arrest those children, and you know why they were found in the first place? Because burglars ram-raided the side of the building to get in, to steal the drugs. And in that commotion, the residents called the police and said there's, a break-in, there's, terrible noise. And the police then came. They found 4 children cowering in bushes with tears coming down their faces because the intruders had thrown tear gas in. Now, N was my client. The other 3 had disappeared by the time I got N's case. He had already served his sentence, and the NGO came to me and said, look, we've got this child, and can you think about, overturning his conviction? He'd been prosecuted, the cannabis cultivation, and he was in a terrible state. He had even been asked to admit to a probation officer that he knew what he did was wrong in order to have his sentence reduced. But his account to the police, which was never ever challenged, was that on one occasion when he had tried to tell the trafficker, I don't want to do this anymore, I need to go, the trafficker said, if you go anywhere, I will find you and I'll kill you and your family. I've made an investment in you. You will continue to do this. And you have to think, if that was a British child, would that have been the same response to just keep going through the system in the way that it did? And with such tension, so when Peter and I took that case in the Court of Appeal, we thought, having established non-punishment years before, there would be no discrimination. Because why? Because it's the trafficker who decides the exploitation for the victim, not the victim. A victim might agree to do something, but of course, in adult cases, the means will nullify their consent. And in the case of a child, you're never looking at consent. But what if someone's recruited for one form of exploitation, let's say a woman, into domestic servitude, and then she's taken out and put into sexual exploitation. It's always the trafficker's intention to exploit that the whole criminal justice system needs to focus on, not the victim's role, because we're looking at power imbalance here. Now, of course, the case failed, in the British courts, and it took 9 years for resolution of that matter in Strasbourg. And that was 9 years that I walked around thinking I had a target on my back, because I thought, well, if this case fails, what's that going to mean for my word, for my arguments, in everything that I was doing? Trying to move the spectrum on every single time into different directions towards protection. The Council of Europe was becoming more and more right-wing. Let's face it, different governments were taking power. And the fear that I had was, what if the court has a composition that is going to find that this was not a violation of Article 4, because the British court couldn't take or countenance applying non-punishment to drugs cases? How will the European Court of Human Rights? But justice prevailed with a unanimous judgment in that matter, which was very, very, very good for victim protection, not only here, but globally. And now, there's a lot of movement on non-punishment, because it remains the one single aspect at the first point of connection between a victim and the authorities that can tumble the whole of the rights system. So, for example, migrant workers in the Middle East. Let's look at some of the races. So we've got people from India, from Pakistan, from Sri Lanka, from Nepal, just as examples. In impoverished situations or lack of job opportunities, who are recruited through recruitment agencies to go and work in the Middle East. The job seems attractive. The advert on the TV or how it's presented to them makes it a no-brainer. That's got to be the outcome for them and their families. The recruitment fee will be between £5,000 to £10,000 in some cases. So each worker is taking that debt on, either as a form of personal debt that they take on in their home country, or they've sold land, etc., or it's then to be applied in the country of destination as an adjustment to any income. And why is it so successful that we see so many cases of forced labour on construction sites and of migrant domestic workers in private households and of chauffeurs outside hotels in these conditions? Because of race discrimination, because those countries are not giving rights to those workers. And that's where the tension still lies. Because if we're sending people to countries that haven't ratified the Palermo Protocol, for example, on trafficking in persons, that haven't got an obligation under international law, or even have decided to obtain obligations for themselves by setting up an identification regime for victim identification to enable lawyers to represent victims who are found needing assistance, you're not only going to never get any prosecutions of perpetrators in those countries because there's no political will to bring down the status quo, because you're never going to get witnesses able to give evidence. But what happens in each of these cases usually is that any time one of these workers goes to the authorities, they will be immediately deported, because their existence on that soil is through the obtaining of a visa to work only for that person. So they don't want to go to the authorities because they're afraid to go to the authorities. And so this is, again, another way that not only demonstrates the perpetuation of people in conditions of slavery where they consider there's still hope, perhaps, that they'll get paid at some point, or they fear the consequences of going back and having given up because of the dire outcomes for the family of debts not being paid. But also, in all of that melee, we see a situation where ultimately there's no chance of justice. And again, in the Middle East, dissimilarly to the European system, for example, or the inter-American system, we have no regional court that can bring the cases there. So let's just then move a little bit geographically into the Inter-American Court of Human Rights system. There's a great case, if any of you are interested, looking at, called Brazil Hacienda. Now, this was a case which was very much about race, as well as deep inequality and poverty. And it involved a number of workers of Afro descent in Brazil, where that's a minority group, who were continuously being employed to go and work on farms. And when they were there, they were subject to all terrible kinds of treatment, similarly to those signal workers, but really without any type of hope that their situation would change. So, for example, there were 85 workers. They were subject to fraud, deceit, debt bondage, inhumane work conditions, lack of freedom to leave. And the matter went all the way to the Inter-American Court of Human Rights in the landmark judgment on slavery, because each system as well uses different laws to describe what we're talking about. And that's why modern slavery is broader than human trafficking, because human trafficking is that definition I told you, that three-part definition, which actually has about 100 words in it. So it's quite difficult, definitely, for victims to self-identify when even lawyers struggle with the concept sometimes. But what is modern slavery, just to tell you before I come back to this case, we're talking about an umbrella term. So I'm a barrister, someone's a solicitor, we're both lawyers. It's just an umbrella term, lawyer, doesn't mean anything in England. Modern slavery is like that. There's no definition of it in law, but it encompasses trafficking, it encompasses slavery, servitude, forced labor, in some countries, illegal adoptions, in some countries, forced marriage, in some countries, the debt that is handed down through generations. So what we have then in the Inter-American Court of Human Rights is the traditional slavery definition that was originally in the Universal Declaration on Human Rights, that then transported into the ICCPR, and then we see it in the Inter-American Convention on Human Rights. And so that was the first case where it was declared, very recently, I think it's 2015, that, slavery is jus cogens now in the world. So that means it's sorry, you're saying no?
No. I mean, the International Court of Justice has declared it's much, much earlier.
Oh, I'm talking about okay, sorry. I'm talking in the context of a slavery case. Yeah. So, and so what they said there was that the inequalities that were there that led the workers to be in those situations was something that Brazil had known about for years and years and years. And they had never taken preventative measures. And so it reached findings against Brazil. And it was a very strong judgment that enables, frankly, researchers and lawyers to look at what more can be done, what more cases can be taken. And that's a critical feature of jurisprudence in this field. Talking again about prevention and race, so aside from VCL and AN, where the court looked at all of that spectrum of what was known, and incidentally, all of those findings by the court on what was known were in a document which I submitted to the Court of Appeal back in 2011. And I had received an order from the court that this was not acceptable because it was too long for the court, and that I had to summarize it into much shorter detail when I was trying to unpick apart the whole of a system. And so it was very encouraging 9 years later to see the court actually adopt that work in their findings. But for example, in Rantsev and Russia and Cyprus, a case that some of you may know about, this was the first case, of course, where the European Court of Human Rights found that trafficking per se falls within the prohibition on slavery, servitude and forced labour under Article 4. And it was a case involving a young woman who had been trafficked from Russia into Cyprus using what was called an artiste visa. And that visa was something, for dancers and people of that nature to be able to reach Cyprus and work there lawfully. But it was well known and had been debated in the parliaments that artiste visa was being used as a ruse for human trafficking for sexual exploitation of women. And in that case, she was trafficked into Cyprus. She managed to run away at one point, and she was arrested. And the police then found who the visa was linked to, rang him up, said, "Oh, we've got this lady here." He said, "Oh, yes, she just popped out. I'll just come and pick her up." Went and picked her up, and the next morning, as you know, she was found dead at the bottom of a block of flats. So no protective thoughts given whatsoever by the government to that system that is built into traffickers' business plans. And this is something that I want to talk to you about. That whenever governments and states discriminate or close a blind eye or turn a blind eye to practices which they know expose vulnerable categories of people to being trafficked, this is something that traffickers are noticing. And they build it into their business plans because they know that they can traffic and enslavers can enslave people of those profiles, knowing full well that if these people come to the attention of the authorities, they're more likely to be either deported, if it's an international case of trafficking, or arrested, if there's been any unlawful behaviour, or handed back to a trafficker, for example, as in said, than the trafficker themselves being exposed by the system. A similar case was in Chowdhury in Greece, which you may know about. This involved a number of Bangladeshi workers who were in Greece working in Manolada on strawberry picking fields. So this was again something that the Greek government had debated in Parliament. They knew that this type of labouring was rife for exploitation, and nothing was ever done about it. An interesting feature of that case was in all of the applicants' cases, they were illegal entrants to Greece. And that as well increases their vulnerability because it's so easy for the perpetrator to threaten a denunciation to the authorities. It's a way to control them. And that's one of the examples of what abuse of a position of vulnerability engages, a threat of denunciation, for example, and isolation of somebody. And so in those cases, when the men and women were on, working and they weren't receiving then payment, then they, got together and peacefully demonstrated and to ask, only because they saw another group of workers arrive and they desperately realised that their places were about to be taken by a new batch. Without having been paid, they'd been kept in deplorable conditions. Their movement was not restricted to one place, but of course they were restricted because that was their job. They were working there, were hoping to get the money and being able to be recompensed for what they'd given in terms of their human labour. And during that peaceful protest, the owners of the farm had their armed guards open fire on them, and a number of the workers were injured. And when the case went to the domestic court in Greece, there was a fundamental failing where the prosecution failed because the court found that because they hadn't been restricted to one place, it meant that they hadn't been trafficked and that there was no forced labour. And so that is one of the points that ended up in Strasbourg in 2017 for the judgment there, where the court made very clear that freedom of movement is not a sine qua non of trafficking or forced labour, but it's one of the indicators that may exist, because a person may come and go quite freely to the observer's eye, but they're chained or they're psychologically bound in a way that is invisible because of debts or because of waiting for payment or because of hope. So again, these are cases where they exposed a lack of interest in minorities' positions in the way of helping communities to be prevented from being trafficked. And then what we then do is when we stand back from it all, what we see is that how can we start to move the compass point more towards protection in these cases? You know, I'm not an expert on race. I'm an expert on human trafficking and modern slavery. But so many of my cases involve race, as well as gender issues, and as well as poverty issues, and as well as other inequalities. But for today, I'm just focusing on race. And it strikes me that one of the best ways to devote more opportunities for success in unraveling not only the links between modern slavery and race and human trafficking, but actually moving towards seeking to combat slavery and human trafficking and forced labour based on race, is by joining together the anti-trafficking community with the anti-racism community, because the two forms of expertise are really needed. This isn't my idea. This was an idea that was raised by the UN Special Rapporteur on Trafficking Against Persons, Siobhan Mullally, in 2021 in a statement on racism, xenophobia, and human trafficking. And, you know, I've been her counsel, and as you know, I was her counsel in the Basfar and Wong case in the Supreme Court, which was the first in the world to lift the diplomatic veil of immunity in relation to the opportunity to claim civil damages for trafficking against a serving diplomat. And in that case, just to wrap up, what we were looking at from our perspective as the independent third-party interveners was to try to expose to the court the real risk of perpetual trafficking. Because if you have diplomats that are allowed, whilst they're serving, to traffic migrant domestic workers from overseas, and in the country where the exploitation takes place, there's no protection for that person, not only in terms of running away and getting shelter, I mean, in that case, she was able to, but in terms of being able to achieve justice, which is the right to claim remedy for your unpaid wages and for your ill treatment, then running away is no point. The victims of trafficking probably stay in that situation because they always have that hope that at some point they might get paid, and that's abused by traffickers. And so we wanted to shine light, and I don't know if any of you have seen our intervention. It's available online at the Office of the High Commissioner for Human Rights' website. So it's intervention in Basfar and Wong. We shone light on the fact that migrant domestic work is very dominant from the Philippines, in diplomatic households, and also very dominant of it being a gendered role, a woman's role. And so without the law being able to protect, you're actually just turning your back on a whole community of persons, when as the United Kingdom, there should be a responsibility by the law to appreciate racial and gendered disparities when it's happening on our land. And then just take one whole step back, and we remember Somerset's case, which was the first case of slavery that was dealt with by the British court. And it was the first finding that there shall be no slavery on this land. And there was no racial discrimination in that case. It was a pure judgment of law, which applied so importantly to a whole body of case law that came later. And that's where I end, which is that law needs to be neutral. It needs to apply to everybody. So that non-punishment case where we won because it was a girl and it was sexual exploitation and she was from Nigeria and everyone got it wrong and that was great, should have been a golden thread that ran through to N's case in 2011 because he was a child. He was from overseas. He was unprotected. He was being trafficked by a really, really violent exploiter. But when they don't converge, you have discrimination, and discrimination is not entitled to be within the practice of law. And that's why all of these cases are so important for what they show, which is by keep going, by keep arguing, by keep challenging, and by using law, whether it's in novel ways or adjusting the compass point towards right protection, we can get there in the end, sometimes. Thank you very much.